Welcome everyone to the Indonesia study group discussion for this week. And this week we're very fortunate to have Rini Astuti, who has been doing a postdoc at RE at NUS, but is now as a research associate with this project on boundary governance of the commons in Southeast Asia. And Rini, fortunately, is now a colleague of mine. She's become a visiting fellow here in the READ program at the Crawford School. So welcome to READ, a belated welcome. And also we look forward to hearing your talk, Rini. You've got about 40 minutes, if you don't mind, and then we'll open it up for questions. So please go ahead, Rini.
Okay, so thanks, John, for the introduction. So before I start my presentation, I would like to also mention that this draft of the research paper is a product of collaboration with a colleague of mine, Dr. Yuti Aryani, who is based at Nanyang Technological University in Singapore. So my today's presentation title is Science in the Court, Expert Knowledge and Forest Fires in Indonesia's Plantations. So we are interested in examining the work of the expert witnesses in the legal proceedings of the plantation fire cases in Indonesia. So this research was actually inspired by a very famous plantation fire case in South Sumatra in Palembang. So in 2014, the District Court of Palembang have given a victory to a company. It's called Bumi Mekar Hijau, acacia plantation, situated in South Sumatra, that was suspected of using fire for land clearing, that was resulted in more than 10,000 hectares of peatland burn. So the Ministry of Environment and Forestry then brought this company to the civil court in the District Court of Palembang. Unfortunately, the judge then decided that the company is not guilty of this allegation of using fire. The judge made a very controversial remark. He said that because the fire did not provide a significant environmental impacts, because the acacia, they can still grow on the burned peatlands, then the panel of judges thought that, well, why then we give this penalty to this company? So they decided to set free the company. And of course, that decision caused a public uproar, as we can see from the media headlines here. In the left here, after that uproar in the media, the District Court of Palembang admitted that they are lacking of judges who understand environmental knowledge. And in the middle here, it's a media headline that is actually asking a question. Is it difficult to punish companies which burn forests? And then in the left here is a media headline that discusses the consideration that Hakim Parlasana Baban, the lead judge in that case, in giving victory to the company. So this article discuss how the judges found that the expert witnesses from the company and from the ministry, each of them use different methodologies in assessing scientific evidence. And the judges then decided that they prefer the argumentations made by the industry-affiliated experts. So this research is actually wanting to then assess what kind of scientific arguments made by the expert witnesses in the court. So just to give overview on the politics of large plantation fires in Indonesia. So in 2015, we all know that Indonesia suffered from a very big episode of forest and peatland fires. More than 2.6 million hectares, I think, was burned. And since then, the Ministry of Environment and Forestry brought around 17 companies to the court. And in the 6-year spans after that episode of fire, 9 cases have reached legally binding status, which the government fortunately won all of them at the Supreme Court. And it is important to mention one of the very famous case of plantation fire as well in 2014. Rawatripa, which is a peatland area situated in Aceh, was burned, and the District Court of Melabo sentenced PT Kalista Alam, this is a palm oil company, using a strict liability principle to pay a very hefty financial penalty, more than 300 billion rupiah for the environmental damages that they cause. They are found to use fire for land clearing. And this has set a very good precedent for law enforcement in Indonesia. However, after this, after several companies have been then fined by the court to pay penalties, in 2017, GAPKI and APHI, the Palm Oil and Pulp and Paper Producers Associations, submitted a review to the Constitutional Court and asking the court to abolish the strict liability principle in our environmental law. And of course, this gained media attentions and protests from the civil society organizations. And because of this public uproar, they withdrew these requests. Unfortunately, and the lobby from the private sector continues. And I will talk in the next slide that this request then is accepted and accommodated by the Jokowi government in the new omnibus law that was passed last year. Another significant incident is in 2018, a palm oil company, PT Jatim Jaya Perkasa, tried to then shoot an academic based at IPB, Bogor Agricultural Institute, Pak Bambang Heru Saharjo, which actually who represents the ministry as their expert witnesses. So PT Jatim Jaya Perkasa was convicted of fire negligence and was fined, I forgot how much, but it was a very hefty fine. And they then problematized the scientific evidence provided by Pak Bambang Heru, because the scientific evidence was printed on a paper with a university's letterhead instead of the ministry's letterhead. So this small technical stuff was then used by the company to try to threat this academic in the legal lawsuit. Fortunately, the South Jakarta court then rejected this legal case and also set a good precedent for expert witness protection in Indonesia. So, as I mentioned, the Jokowi government submitted this omnibus law to the House of Parliament, and the House of Parliament then passed this controversial regulation in October last year. And the government claims that this regulation, this law, is created to then simplifying regulation to attract investment, and in return will create more jobs. But civil society organizations and environmental academics in Indonesia found that there are two significant changes that the omnibus law then introduced to our environmental regulation and protection. The first one is on Forestry Law Article 49. So here I try to highlight the changes. So the omnibus law derives the clause of Article 49 in our forestry law which states that companies have to be responsible of forest fire by changing the provision from to be responsible into shall try to be responsible. So the new article, which I highlight yellow here, then sneak in one word, berusaha, which is very ambiguous, of course, and it will be very difficult later in the court to prove what berusaha means, because this is provide very big ambiguity. And then the second change is that the omnibus law removes the strict liability principle. Strict liability principle is a very one of very strong, even the strongest actually, strongest principle in our environmental protection, because it forces businesses with high environmental risks to be fully responsible for any environmental damages that they cause because of their business activities, without the need for the government to prove their intentional misconduct. However, this clause or this phrase of without the need for the government to prove is then deleted in the new article under the omnibus law. So there is no more strict liability principle that can be used by the judges to then sentence plantation for the fires that happen in their concession. So what does this mean for forest and peatland fires investigation? So with the abolition of the strict liability principle, then the ability for the government, for the Ministry of Environment and Forestry to then try to hold companies accountable is only by producing a very rigorous scientific evidence that the company failed to stop forest fire in their concession. And according to interviews with government officials, forest fire investigation is a very lengthy, complex, and expensive process. They have to send a team of investigators, and usually land fires in Indonesia happen in a very remote areas. Sometimes there is no road toward this remote location, and because of this, large plantation that have access to resources, to technical expertise, and then to other means, can then have, I think I can say they will have more opportunity and power to define what is fire, and then who is responsible for this fire. So this is what will happen under the omnibus law implementation. And because of the unique situation in Indonesia, well, I think maybe not only in Indonesia, but everywhere in the world, there is an increasing use of satellite-based images to help in forest fire investigation. So, as I mentioned, this research is interested in examining the work of the scientific experts in the fire trials, and also respond to a call for further researching the potential implication of the omnibus law implementation toward environmental protection agenda in Indonesia. So this paper is guided by 3 questions. The first one is, we try to answer who are the experts and with what kind of expertise delivering testimonies in Indonesia's plantation fire trials, and what are the key narratives that they construct, and how do these narrative or their scientific arguments shape the judge's decision. Our analytical works is inspired by literatures on knowledge politics. And one of the main articles that we refer to is written by Jenny Goldstein in 2016. So divergent knowledge. So Jenny did a research on the epistemic networks in Indonesia that use their scientific arguments to provide a support for legitimation of the changing of land and forests and peatland in Indonesia into agricultural plantations by undermining the environmental impacts of this conversion of land to agricultural plantations. And this epistemic network, they usually publish their articles not in globally accepted journals with peer review process. They usually publish in platforms that are more free in Indonesia. However, because of that, then they have more reaching towards the policymakers, and most of their research are usually supported by palm oil producer associations such as GAPKI and other big companies. And we also found actually that this epistemic network also serve as the expert witnesses for the companies that are then caught in the legal lawsuit against the Ministry of Environment and Forestry. And this divergent knowledge that this epistemic network use is working by underestimating the environmental impacts of land use change, and they also aligns extractive economic interests, which is the conversion of land use, with the domestic interest and national pride, such as the palm oil and the pulp and paper sectors. And it also associates criticism and environmental protection agenda with foreign interests. And of course, when we do research on expert witness, we also try to understand the literature on expert witness. In Indonesia, expert witness is broadly defined as a person with a specialized knowledge that then can be used by the court to provide clarification on a specific issue. And interestingly, in a socio-legal scholarship, researchers have argued that the way to understand the significant role of expert witness in the court is by evaluating the number of citations that the judges have made toward their testimonies, toward the expert witness testimonies. And of course, expert witness credibility is also strongly influenced by their affiliation with trustworthy institutions such as universities. And there are criticisms concerning the use of scientific experts because, of course, these experts may have used divergent knowledge or junk science, and they can cherry pick data as well, and may even have vested interests that will, of course, shape their judgment and assessment. So just a bit of overview on the judicial system in Indonesia. In Indonesia, our legal system follows the judge system, in which a panel of 3 judges rather than a jury will be the triers of the fact. And then when forest fire cases brought to court in civil court, it usually then fall under the common courts in Indonesia. This common court in Indonesia consisted of 3 tiers. The first one is district court or pengadilan negeri at the district level, and then high court or pengadilan tinggi at the provincial level, and then the highest one is Mahkamah Agung or the Supreme Court. And if a party in a lawsuit is not happy with the decision of the judges, then they can appeal to a higher court. So how do we collect data in the time of pandemic? So we collect court documents from an online directory. Indonesia now has a very good online directory of court documents from all over Indonesia. And we only assessed documents at the district level, actually, because this is where the expert witnesses were being called to come to the court and provided testimonies directly in the court. And we only assessed 9 cases of plantation fires, because these 9 cases have reached legally binding status. And we also then analyze secondary materials such as regulations and news articles, and we did interviews, which we also benefit from the interviews that we conducted previously for other papers with NGO activists, expert witnesses, and government officials. And during the pandemic, there were many webinars on forest and peatland fires, in which some of the speakers were also expert witnesses in the court. So this is the list of the 9 plantations that we assessed. The one that I highlighted in yellow are those that won the cases at the district level. So the first one is Bumi Mekar Hijau, Acacia Plantation in South Sumatra, and then Surya Panen Subur, palm oil, Riki Kurniawan Kerta Persada, palm oil, and Palmina Utama, palm oil. So out of these 9 cases, 4 won at the district level, but then the Ministry of Environment and Forestry appealed to a higher court, and they won the cases. As we can see here, the numbers of the penalties that they have to pay to the government. So, however, it is important to remind us all that we only analyze documents at the district court level. So, how do we do a data analysis? To assemble intelligible argument, we employ a discourse analysis, because discourse analysis then help us to unpack the scientific arguments that the expert witnesses produce in the court. And following Hayer's suggestion, we try to identify storylines. And we identified 3 storylines that actually are common and make the basic of the court deliberation, which is contestation on fire occurrence, debates on the fire responsibilities, and assessment of the fire impacts. So on findings, back to our research question. Research question 1 on who are the experts and with what kind of expertise delivering testimonies in plantation fire trials. So to answer research question number 1, we tried to make a database of all of the expert witnesses who have provided testimonies in the court across 9 cases, both from the companies and from the ministry. So we found 36 expert witnesses that have delivered 93 testimonies. So one expert can then be involved in multiple cases. And out of these 36 experts, only 11 individuals represented the government, and then 25 represented companies. And this actually shows that the government has limited pool of experts who are willing to represent the government. And this is an interview with an academic expert who represented the government in all 9 cases. He said that not many academics are willing to serve as the government expert witness because They face complex challenges from legal lawsuit to violent threat, and even their families are being threatened. And they're being constantly undermined and become a victim of black campaigns, even within the faculty where they work as an academic in their university. So this, I think, sum up the challenges that they face when they try to stand up toward big plantation companies. And to enable comparison and analysis, we try to then classify the expertise of these expert witnesses into 4 categories. The first one is on forest and environment. We found 14 individuals, and then law, we also 14 individuals, and meteorology and climatology, and then agronomy. So unsurprisingly, of course, the highest expertise found in this database is forest and environment. As of course, in the court, these are the testimonies that are needed by the judges to provide clarification on the case. And then to understand who are these experts and what kind of epistemic network that they're attached to, we try to then understand their institutional affiliation. So here in this graph, we found that the blue one represents 27 individuals that are attached to universities in Indonesia. And then 2 individuals from government ministries and institutions, 5 are actually retirees of judicial agencies, for example, pensiunan hakim, pensiunan mahkamah jaksa, and etc. And then there are also 2 individuals associated with private law firm. And interestingly, out of 27 academics from universities, 16 are affiliated to Bogor Agriculture University, or IPB. And out of the 16 academics, only 3 actually represent the government. And this density of expert witnesses coming from one university is actually, we argue that it represents the similarities of their ontological beliefs toward forests and their role. Because in Indonesia, it is famously known that foresters in Indonesia are taught on scientific forestry, and scientific forestry is a field of knowledge that then give foresters in Indonesia the belief that forests are there to be exploited. And this has been then confirmed with our interviews with some academics. So in order to understand the significance of expert witness testimonies in the court, we try to quantify numbers of citations or references that the judges made when they make their final deliberation. So across 9 cases, we found judges have made 194 references toward expert testimonies. So it means average, there is around 21 citation per case. And I think it's a good indicator that expert witnesses' testimonies are actually quite important in shaping judicial deliberations. And if we can see here in the graph, the blue one represents experts from the ministry, and the orange one is from the company. And the numbers here is number of citations that the judges made. And of course, unsurprisingly, forest and environment expertise are the expertise of knowledge that have been referred mostly, or the highest that have been referred by the judges. And we can see here that actually the judges prefer to refer to testimonies from the government's expert witnesses. But we found that out of 9 cases, only 5 that the ministries won the cases, and 4 companies were acquitted by the court, despite a number of citations that the judges made toward the expert testimonies. So across 9 cases, we only found one company that actually one case in which the company's expert witnesses then referred more by the judges compared to the expert witnesses from the government. So this quantification, of course, doesn't provide overview on the discourse debates within the court itself. How do that happen? So this is the role of the discourse analysis. How do then arguments made by the judges, made by the scientific experts really shape the judicial deliberation, which then we will answer in the next section. So the next finding is we try to answer research question number 2 and 3 on the key narratives that the expert construct in their scientific arguments, and how do these scientific arguments then shape the judges' deliberation. So the first narrative, the main narrative is on contestation on fire occurrence. So deciding whether fire occurred in a plantation is very important to decide whether that company is found guilty or innocent. And usually, when in the aftermath of fire, the ministry then will assemble a team of investigators consisted of experts on forest and environment, and then government officials from both the local and national, and then police officers as well. And the company, since they know that they are being brought to court, they will also then assemble their own investigator, which is also, of course, consisted of academics expert on forest and environment, which are usually coming from the same university as the ministry's experts, so that in the face of the court, it will look like that they provide the same level of scientific rigor. And then this team then will contest their scientific assessment on the occurrence of fires in the court. So one of the most contested scientific evidence in the court is fire hotspot. So the ministry as expert witness will start forest fire investigation with analysis of satellite images, and then they will try to get these images of hotspot. So hotspot is usually defined broadly as representing a location with a higher temperature compared to the surroundings, and how to then a satellite try to differentiate between fire and other is by using infrared technology. And the ministry team usually then use this satellite-based image containing hotspot, and then try to then overlay this image of hotspot with the physical layout and border of the companies to understand whether fire actually happened inside the concession. And the ministry's team use hotspot with a confidence level of 80%, which is the highest confidence level. That is also used by scientists in C4 for their scientific assessment for paper production. And in contrast, the company's expert witness always argue that hotspot without real-time field verification are inadmissible for scientific evidence in the court, because usually when the fire happened and then because of the bureaucracy, it will take some time for the team from the ministry to then come to the field to conduct field verification. And then we found that in the Bumi Mekar Hijab case, the judges then found that these arguments from the industry affiliated experts on the inadmissibility of the hotspot as a scientific evidence they use this argument and then to acquit the company of the charge. And finally, in another case, in the Palmina Utama case, we found that industry affiliated experts tried to then problematize the 80% confidence level by saying that because it's only 80% and not 100%, then it's unreliable scientific evidence. And this argument was then subsequently cited by the judges as well to make his final deliberation in favor of the company. So even by referring to the same satellite images, the ministry's expert witnesses and the company's expert witnesses, they can come with a different scientific arguments based on the ontological beliefs and the kind of science that they use to make arguments. And the second narrative of the main storyline that also comes up in the court documents is debates on who is actually responsible for the fires. Because even if the fire happened within the concession, so who ignited the fires and who caused the fire? That's being contested in the court. And it is important to understand that concession boundaries in Indonesia are, of course, still disputable and contested. We don't even have one map of concessions in Indonesia. And companies often, they benefit from these obscure borders and overlapping concessions and land tenure conflicts. And because sometimes the satellite images are not very clear, and this then, when it is being used to then overlay with the hotspot, it provides considerable room for interpretation, and because of the overlapping concession and land tenure conflicts, then it provides opportunity for the companies to say that, well, it's not us, it's the communities that actually started the fire. And our analysis across 9 cases show that expert witnesses that are affiliated to the companies always try to then redirect blame and change the narrative that even if the regulations say that the company have to be responsible for the fire within their concession, but when it is started by the community, it's the community's fault, not the concession. And in doing so, actually, these expert testimonies distort the narrative of fire ownership and portray the companies as the victim instead of the perpetrators. And this has shaped actually judge deliberation in some of the cases, which I forgot which one because I cannot open my notes. But yes, it has shaped this portrayal of companies as a victim, then really then shaped judge deliberation in favor of the company. And another debates on fire responsibility is, of course, involving the role of weather. This is strongly advocated by the industry affiliated experts that because of the weather, fires that jump from the community to the concession spread very quickly, and then it's outside of their power to then control the fire. And so their argument is that instead of looking at this fire as environmental crimes, then it has to be classified as a natural disaster. And this again portray the companies as a victim instead of a perpetrator that has to be responsible in managing their concessions. So the final storyline that we tried to assessed in the court document is on the assessment of fire impacts. Again, we remember what Jenny Goldstein argued in her paper on divergent knowledge is that epistemic networks that are close to the industry try to undermine environmental impacts of land use change. And we also then found that experts from that are affiliated to the industry also try or tend to undermine environmental damages from the fire. So their argument is usually by saying that because this is a plantation, so if it's burned, if the land can still be used to grow the crops, then there is no significant damages. Because when you try to apply a standard for environmental damages, you have to see what is the function of the land. That's their argument. So this myopic view of environmental damages is then shaped their arguments about the impact of fires. And unfortunately, this view was cited by the judge. And if we remember in the Bumi Mekar Hijau case that I have presented in the earlier slide, that the judge also believed that since the acacia can still grow well, then there is no significant damages to the land. And even we also find it quite shocking that some of the expert witnesses say that they disagree with the assessment from the ministry's experts on the impact of fire from the impact of fire on biodiversity. Because if there are many types of grasses still grow on the land, how can that be said that there is no biodiversity there? That's their argument, which we find quite shocking actually. And the last one is on carbon emissions. Of course, this is a very contested aspect in the court document as well. And commonly argument in all 9 cases also mention that carbon emissions from forest and land fires are very difficult to assess. And this is because of the contribution of the plantation crops in reducing emission. That's one of the arguments that commonly used by the industry affiliated experts. And when they try to build their argument, they then try to grab the climate justice discussion on the role of fossil fuels in the Western context compared to the emissions from land fires in Indonesia. So their argument is that land fires in Indonesia is insignificant compared to the fossil fuels from the Western nations. And these views on carbon emissions were cited by the judges in determining the amount of penalties that the companies have to pay because of the scientific arguments by industry affiliated experts that says that it's very difficult to assess the economic loss from these carbon emissions. Then the judges also agree with this and tend to then minimize the financial penalty. And of course, we also found that companies experts also then try to argue that the ministry's experts view on fire is usually it's not supportive of the national development agenda, because ministry's experts are usually attacking these companies instead of then providing support for a domestic significant agricultural sector, which is, for example, palm oil plantation. So I come to the last slide, which is the conclusion. This is still very preliminary in our paper, but we can say that expert witness, of course, they arrange scientific argumentation to advance their respective client interests. And sometimes in the context of industry affiliated experts, they are making claims that sometimes contrary to the generally accepted scientific arguments. And in doing so, this has successfully shaped judicial deliberation at the district level. And in the context of the omnibus law, which then will require rigorous scientific evidence, it will be more difficult to hold companies accountable for their significant socio-ecological impacts toward peatland and forest zone in Indonesia. I think that's it, and thank you, and looking forward to the discussion.
So thanks, Rini, for a very interesting presentation. And also like to acknowledge the attendance of people from very wide geographical areas. I think we have Dom Emerson from Stanford University here. We have Wolf Dressler in Melbourne, Carol Warren over in WA, and Pak Wasino from Semarang State University, and many other colleagues from Indonesia. So welcome to our seminar today. Okay, so you have two ways to ask a question. You can type it in the question and answer box, and I will try and give those who've done this a chance to ask it directly, or else you can raise your hand. So I might move to the question and answer box first of all. Would Ibu Lydia and perhaps Kenny like to ask their questions? Maybe I'll get them to do it sequentially. Can we, actually, I'm not sure we've got an open forum. Maybe, maybe we just, so the first question from Ibu Lydia was, have you looked at how many of the forest company owners, managers or staff are IPB graduates? This might explain the link between expertise where networks are used to identify and recruit experts. And so is that a, okay. Also, Lydia, could you ask the question directly? I think you're allowed to speak now, Lydia. Please go ahead, Lydia. I think you're on mute.
Oh, sorry, I've been doing some other things. Can you hear me now?
Yes.
Yeah, okay. Hi, thanks very much for the great presentation, Ibu Rini. My first question, as was read by John, is the link between owners or managers of forest companies and the experts themselves. Because, you know, as in Indonesia, the network and trust is higher when they know each other, former students, and so on. So experts then feel more comfortable because they think that they can trust their former students, that they will not be led astray. The second one is about Ministry of Forestry. How do they decide on experts? Are they allowed to bring in international experts? And have they looked at the international experience in similar court cases so that they can use the best available scientific evidence and not rely on domestic expertise? If you can allow me also, perhaps, oh, okay, just those two. Thank you.
I might allow Kenny to also ask their question. I think we group three together if Rini's all right with that. So Kenny and then Colum, so we can do it more economically in terms of time. Please, Kenny, go ahead.
Thank you, Mbak Rini. Thank you for your presentation. It's very interesting. I have a question. Is it also within your scope of your research to propose like solutions for the to solve the conflicting opinion among the expert witnesses? And if yes, maybe you know, maybe from the scientific perspective, which kind of opinion should be followed by judges? Because previously in your background, I think you also mentioned that some of the judges, they have a lack of knowledge on these environmental science, something like that. Thank you.
Okay, so then the next question I think was by Colum, and we'll let you answer them all, Rini. Please, Colum, go ahead.
Colum said that he doesn't have a microphone set up on this PC.
Okay, So his question is quite a long one. I won't read the whole thing. So he's asking, is there a relationship between the size of the fines and if a company was acquitted? What explains the fine size? Okay. Did companies? That's too many questions there, Colum. So Rini, please go ahead.
Okay, so first question from Ibu Lydia. Thank you, Ibu Lydia. That's actually a very good insight about the connection between companies' connection through the inside connection from company staff or managers toward the expert, which is usually are the alumni. So these companies' managers are usually the alumni of the expert witnesses who are being used by the companies. Yes, of course, that also affect how they chose the expert witnesses that then represent the companies when they're in trouble. But the thing is, which we need to understand is that the kind of knowledge that they use, this kind of scientific arguments that these experts construct, right? And as I mentioned, it's usually shaped by their ontological beliefs. And in IPB, I read an article about the scientific forestry's ontological belief in among the foresters in IPB. And how does Ministry of Environment then select their expert witness? So far, there is no international expert being involved directly in the court. I haven't really actually checked if it's allowed in our regulation if international expert can then be can provide testimonies. Maybe if there is Simon Butt, who is an Indonesian law expert, maybe he can provide explanation on this. I'm not sure about the involvement of the environmental expert, but you are correct, Ibu Lydia, that Ministry of Forestry needs to improve the ability of their investigators, because if we read the court documents, there are so many also deficiencies in the scientific arguments made by the Ministries of Forestry's expert witnesses. And this has become a good discussion, especially inside the Ministry of Forestry. And when I used to work for one of the development agency in Indonesia, one of the call is to actually provide training for academics in Indonesia to be a good expert witnesses. We wanted at the time actually for Australia to provide training of forest fire investigation or fire forensic for academic experts in Indonesia. That's also one of the ideas that at that time we discussed to improve the capacities of expert witnesses who represent the government. And however, the problem is that despite how many trainings, this is based on the interview with one of the academic experts, despite how many trainings, there is no way of preparing your mental ability to face the lawyers who represent the companies, because they have so many tactics actually to make you feel insignificant. They can question your credibility, they can question the way you make your arguments, and etc. So this academic expert who represents the ministry said that only by then standing there and try to be persistent, you can then be able to be an expert witness in the court. That's what he said. I myself haven't really actually followed in the court directly for this research paper. So that's one of the limitation of this paper actually, that we didn't attend directly in the court and see the direct testimonies when it happened. Thanks, Ibu Lydia. And then a question from Kenny. Kenny's question is on how to then address the differences on the scientific arguments made between these two opposition. Well, in this paper, it's beyond the scope of my research because these are, of course, again, back to the ontological belief of each of these experts in Indonesia, these academics who then represent companies and Ministry of Environment and Forestry. But what can I say is that there is an increased effort to then provide training for judges in Indonesia, training hukum lingkungan, on environmental law and environmental cases, then that can be used to make judges more familiar with environmental cases, and that they are not then vulnerable to fall into junk science. Thank you. And then Column's question on why the find is so diverse and is not necessarily associated with the numbers of land burn. So yeah, again, it depends on how the judges then read the testimonies of the expert witnesses, because expert witnesses will provide argumentation about the quantification of the environmental impacts of the fires. And then the judges make their own assessment based on this testimony. And sometimes we cannot really understand how do this work between I mean the link that make direct connection between the testimonies and the number of fines. But what we believe is that when the industry affiliated experts try to undermine the environmental impacts of the fire, then the judges then also then being influenced to then provide insignificant financial penalty. Thanks.
Okay, thanks, Rini. So we have two more. We have somebody who is listed as number 2, who I don't know who it is. Would you like to ask your question live? Number 2. I don't know.
Oh, hi.
So maybe you can identify yourself.
Oh, sorry. This is Jackie Baker. I actually wrote in my. Oh, yeah. I see. It's come up as my. It's come up as my staff number. Apologies. So, Rini, fantastic presentation. That was a really great topic. I really enjoyed it. I'm also working on deforestation in Riau by pulp and paper companies using social network analysis and using legal archives. So I just wanted to reach out and say that there's some commonalities in our work. But in that work, I found a great paper by, I think it's like the anti-mafia, anti-hutan mafia or something like this on beneficial ownership. And what it sort of indicated was that timber supply companies to pulp conglomerates were effectively run by pulp employees and pulp family members. So they did a kind of very loose social network approach. And I wondered whether such an approach might also work in this field to apply to academics and judicial expertise. I'd say also in the social network analysis I've done, of the sort of the people that come up in the legal archives, I'd say there's a number of academics that are appearing in some of the police investigation reports around pulp and paper, sort of corruption networks in pulp and paper.
Okay, go ahead, Rini.
Thanks, Ibu Jenny Baker. Yeah, so I read actually your paper on the social network analysis on pulp and paper industry in Pelalawan, I think, right, in Riau. And the context of the social network analysis, I think, can be implemented. However, the court documents, unfortunately, is not as, I can say, it's not as detailed as the court documents in the Tipicor. That's the problem. So we actually was trying to adopt your method to then try to provide to understand the social network analysis. But despite we analyze the court document, it's very shallow still. And I can imagine that the Tipicor, Tipicor is the corruption court in Indonesia, and their documentation is very detailed, I think, compared to the common court. And that is the problem when we only rely on the court documents. That's one in terms of the method. And then secondly, on the corruption network, this is just an anecdote, so I'm not sure the extent of the truth on this, but I interviewed some civil society activists, and they said that, yeah, when you provide testimony for a company, you receive substantial amount, and it's, of course, it's not corruption, but that then create a vested interest in the way you then construct your scientific argument. Thank you.
Okay, Rini, we have two more questions. One from Simon Butt, who asks, is it the job of judges to identify the relevant law and then apply it to the facts, not the job of the experts? So does this say anything about the expertise of judges? So this is the end of the question. And so before you answer that one, also I'd like to ask Dom Emerson to also ask his question. If we can somehow make that live for him. Don, do you want to ask your question?
Yes, I would like to ask a question. Forgive me, I missed the opening minutes of your very interesting presentation. So if you've already addressed this topic in those opening minutes, please forgive me. I think there's a danger across the board when there is a problem under discussion and there is a usefully specialized approach to the problem, which is how I would describe your presentation, especially with its focus on the loyalties of experts and so forth. The danger, of course, is that someone like myself will come and ask a question which is outside of your scope, the scope of your research. And I apologize in advance for doing that. There's a difference between punishment and prevention. It seems to me that your focus is after the fact. The fire occurs, and then the questions arise: who did it, and so forth. Is there going to be an acquittal? Is there going to be punishment, and so forth? But presumably, one possible consequence, among many that I can think of the results of a court decision with regard to a plantation fire, is that it could conceivably promote prevention insofar as companies would think twice before, whether directly or indirectly, allowing such events to occur. And I wonder if you would comment on the preventive potential. 4 out of 9 is not really terribly decisive with regard to the record of the court judgments. But could you comment on the impact that might be there, or might possibly be there, on actual prevention of future fires?
So Rini, you could answer those two questions, I think.
Okay, thanks. So question from Simon. Well, I have to make a clarification first that I don't have actually a background on legal knowledge. I'm a political ecologist, I'm a geographer. So this research is, of course, conducted with very limited knowledge on how law works in Indonesia. that's one of the clarification, and of course limitation of the research. In order to answer Pak Simon question on whether it's the judge role in understanding the law, or is it the experts? In my opinion, from a perspective of a lay person who doesn't have a legal title, I think it's both. That's why I think there are many activities now conducted by government agencies as well as development agencies in trying to then improve judges' knowledge on environmental cases. And I think because, like, for example, a thing as not as simple, but like a hotspot, for example, there are many technical vocabularies about hotspot that when experts provided testimonies in the court, then it will be really sometimes difficult for the judges to follow. But when judges have a background knowledge on forest fire in Indonesia, then they can, I think it will help them to then follow the debates between the company's team and the ministry's team. That's my answer, if that really answering your question, but if not, maybe I misunderstood your question. And Pak Don's question on prevention. Yes, Pak Don. This research, of course, it focuses on the aftermath of a fire. It's not on the prevention. So to answer your question on the prevention program on fires, actually, the government of Indonesia, on paper, has done a very good job in switching the fire prevention. Now they are focusing on fire prevention program. That's what I want to say. So instead of the aftermath of the fire, fire prevention program currently is focusing at the grassroots level. So, for example, for companies, they have initiative called Free Fire Villages, that then they work with the communities to patrol the concession border, and then together with the communities try to prevent fires to happen. And under the Peatland Restoration Agency, there are many programs as well, consisted of 3 approaches: restoration, rejuvenation of livelihood, and then construction of like canal blockings and other activities to prevent fire to happen on peatland, for example. And also diverse activities under the Ministry of Environment and Forestry. But I need to emphasize here that in terms of prevention, usually the Ministry of Environment and Forestry will apply administrative punishment first before they then decided to bring a company to a civil lawsuit. From the documentation that I read, between 2015 to 2018, there have been 500 companies that have got administrative sanctions from the Ministry of Environment and Forestry. So it's usually a letter saying that, oh, you have done this and that, you need to do this and that. And I'm not sure the impact of that administrative sanctions, because research from Greenpeace found that there are many companies that actually have recurrent fires from 2015 until now. So this shows that sometimes administrative sanctions as a prevention mechanism is not really effective and doesn't have a deterrent effect. And another interesting research conducted by Jika Lahari. Jika Lahari is an advocacy organization based in Riau. They found that when a company faces a lawsuit, suddenly the hotspot will decrease in the next year. So when you brought the company to a court, then it really works well, because then the hotspot disappears suddenly in the next few years. Thank you.
Thank you.
Thanks, Rini. So we've got three now. I'll give Tom Worthington, Jiri Ahmad Taufik, and Budi an opportunity to ask your questions. Okay, so please go ahead. If you could keep them brief, that would be great.
Okay, it's Tom Worthington here. Can you hear me?
Yes.
Thank you. I've been a expert witness in Australian courts quite a few times, and the first time I was shocked when the defending lawyer said, "I put it to you, Mr. Worthington, you're not an expert, you don't know what you're talking about." I wonder if universities should provide training in how to deal in this situation for graduate students. I mean, it's something legal students would get experience with in the mock court, but in my area of computing or in environmental areas, it's not something students would not normally get any training in.
Okay, Budi.
Yes, thank you very much. So my question is also related to several previous questions, particularly related to your first research issue. From your case study, is there any cases in which the judge is actually clearly defined what is it an expert in the field, and then could say that this one could be an expert or not an expert? If the judge can have those very clear, then, you know, such as comment from that you are not an expert, it's not valid anymore, because the judge is actually has been defining those things. Now, second is also, as in any of those cases, the judge is clearly defined what is the task of this expert. Will the expert clarify what happened, or will the expert argue that that company make a wrongdoing? So that is also probably an important cases for the future. It will be clear what exactly an expert witness role. It's not whether it is actually proving that the person is do wrongdoing, or just clarify what happened. Now, the third issue is part of the first one. How far, what is exactly the definition of independent? So this is related to Lydia's comment on what is it an independent expert witness definition. Thank you.
And then we have finally one more from Giri Ahmad Taufik, if you'd like to.
Thank you, John. But Lydia, it's a great presentation. The question is very straightforward, and it's actually related with the previous questioner and Pak Simon about how actually the judge, in your research, are you looking also on how the judge evaluate the expert arguments? And what do you think about their evaluation, whether it's credible or not? Because last year I also did similar research to this one, and I found that the judge actually only evaluate on what we call as pro forma. So it doesn't evaluate the arguments, the expert argument. It's only evaluate the, whether you have a credibility or not, whether you have SK or not on that particular areas, not actually the substantive of the expert argument. Do you also find similar conclusion? Thank you.
Okay, Rini, if you'd like to answer.
Okay, thank you, Tom. I think that question should be answered by John and maybe Pak Budi or Pak Arianto, because I'm not a lecturer here, so I'll give that to the other panelists here. On Pak Budi's question about Pak Budi's question, sorry, Pak Budi's question, I forgot. But how the expert witnesses, how the judge define expert witness, I think.
Yeah.
Yeah.
Yes.
Yeah. So in Indonesia, there is Surat Edaran Mahkamah Agung, Pak, on the definition of keterangan ahli. So usually, and it's broadly defined in that Surat Edaran Mahkamah Agung. And the judge usually then will ask in the court, this is according to the interview with some academic experts that I interviewed, that they will be asked, usually they provide their CVs with that proof that they have written papers on the topic of, for example, on forest protection or fire on peatland, etc. And this CV then, which Mas Giri Taufik said as pro forma, will prove that this person is really an expert. But as Pak Tom mentioned, the defendant lawyers usually will then question your credibility, and this is what happened as well in our courts. And because our academics, well, I'm sorry if this is a bit harsh, but when they provided CVs, of course, this list of publications is not then being checked whether it's peer-reviewed journal articles or is it in another platform, which is of course less rigorous in their scientific approach. So it doesn't matter whether you have published in a very good top journals or whether you publish in several books that may be supported by or sponsored by big plantation companies. So the court doesn't really check that. And then that's of course one of our weaknesses, and it becomes very loose to define whether someone is really an expert on this topic. And then also, apart from the CV, usually is your list of education that really proves that whether you have knowledge on that specific topic. And in the future, I think if we want to make it more strict than the Surat Edaran Mahkamah Agung, the circular letter of the Supreme Court has to be changed to make it more stricter and more so that real expert, I don't know if there is not unreal expert, but that the expert that needed to be there, that can only be that can only provide testimonies. I think that's your question. Did I miss any of your question, Pak?
The second one is about the judge tell the role, whether it's to clarify what happened or to prove for a wrongdoing.
Okay, yeah. So in the court documents that we read, usually it started with like a statement from the party that brought the civil lawsuit. So in this case is the Ministry of Environment and Forestry. So the Ministry of Environment and Forestry will provide their facts, their claim about forest fires, and then they will say that this has happened, and then their expert will provide testimonies to strengthen that claim about the forest fires, and then the company then will answer all of the allegation from the Ministry of Forestry, and the judge listen to that, and then of course can ask question as well. So the judge, in my opinion, from what I understanding and on how common court works in Indonesia, doesn't then really limit the role of the expert witnesses in only, for example, to provide clarification or to say that the company doesn't do any wrongdoing. So they can do both in the way that I read the document. So an expert witness can say that, yes, fire happened. This is usually what the expert witness from the industry said. Yes, fire happened, but this is not the wrongdoing of the company because the community started it. That's an example of common testimony provided by the industry affiliated expert witnesses. And after Pak Budi was question from Pak.
Running out of time. Rini, could you make your answers short?
Sorry, yeah.
We've got about 4 more questions to go.
Yeah. From Pak Giri Taufik, Pak, because I only assess court documents, despite we also conducted some interviews, but we didn't really interview judges in our research. We only interviewed academic experts. So this is actually one of the limitations as well in our research. But we found in the court documents that the judges make references to the to the expert witness testimonies. So in our opinion, yes, they do actually read that or listen to the testimonies anyway, because the testimonies were conducted directly in the court. So, well, they were there, so they listened to that. Yeah, but whether they really understand that, that's a different question. Yeah, thank you.
Okay, I'll just quickly ask one question, and I'll turn over to Dayu and another other people. I'll just make it very briefly, and if make it brief, and if the others could do that as well. Just listening to you, Rini, I was wondering where I think just the knowledge claims and the politics of knowledge are clearly important, and it's a really good lens. But I wonder whether the real reasons for what you see is happening are actually extra legal. The prejudices, the pressures, the political economy, and the financial resources that these other actors have, and the way that this continues to expand the plantation sector in Indonesia, and this is seen really explicitly in the omnibus law and how it's been reformulated. It's really, is it realistic to expect the court to really overturn this whole, all these forces that are pushing for expansion and leading to forest fires? And I mean, I guess ideally what we would expect, or a second question in a way, would a special environmental court or dedicated environmental judges help? And this discussion's been around for many decades, that Indonesia maybe should have a special environmental court. So why isn't there such a court? Okay, so I'll move on then to Dayu. Would you like to quickly ask your question?
Yeah, sure. Thanks very much, Rini. I enjoyed your presentation very much. Just a quick question. Of the cases that you put in your slides that have been inkrah, so final decision, now I think there are 11. Instead of 9, so there are 2 more. Actually, the Ministry of Environment and Forestry, on behalf of the state, have actually won all of the cases. So all of the 11 cases that are in craft have been won by the state, basically, So either at the High Court or at the Supreme Court, and through the cassation. I understand this is probably outside the scope of the study, but because of the outcomes, the final outcomes, I'm actually wondering whether it would be useful. How do you think the expert witnesses' testimonies affect these final outcomes? Because at the end of the day, the final outcome matters more than the outcomes at the district court levels if they go to the High Court and the Supreme Court level. Thanks.
Okay, so we're running out of time, so I'm sorry I'm not going to be able to allow the others to, I don't know what the Indonesia Project colleagues think, but maybe we should let Rini answer these 2, and if there's time we can turn to the other ones. Please, Rini.
Yeah, so I'll answer Ibu Dayu's question first. Yeah, so we agree actually, Ibu Dayu, with your analysis that in the end, the government actually won all the cases. But why we only analyze the district court, because this is where I think when the ministry loses the cases, the media then played a very big role in portraying the public uproars and the civil society organizations uproar. And this then, I think, provided pressures political pressures toward the judges at the at the High Court and the Supreme Court, and it becoming less significant, the role of the expert witnesses. And I think then the judges prefer to then refer to the testimonies from the ministry's expert witnesses, rather than from the industry. But what I want to say here is that out of the 9 cases that we analyze, so this paper, when the uproar is not there yet, and it's only limited to a small bubble at the district level, unfortunately, the expert witnesses then played a very significant role in legitimizing some of the and swaying some of the judicial deliberation, as we have found in the 9 cases. That 4 companies actually won because the judges then referred to the divergent knowledge that the industry affiliated expert use. I think that's the answer to Ibu Bayu's question. And to John's question about specific court and the powerful omnibus law. Yeah, I know that in the end, after this omnibus law's implementation, nothing can be done by the court, of course, yes. That's also will be in our conclusion. And why there is no specific environmental court, I think maybe that's, I don't know, it's very politically contested, maybe the decision. Maybe has to have pressure as big as corruption cases to have specific court on environmental cases. Thank you.
Okay, well, we've got to 2 o'clock. Apologies to a number of other questions. We just don't have time for them. Maybe you can email Rini directly. So I'd like to thank Rini for a very interesting presentation that really stimulated a lot of questions and discussion. So, and also, you know, this is not easy research to do, so we should acknowledge that Rini has done a good job at trying to understand these complex processes. So thanks, Rini. I think we could applaud Rini. You're on mute, but maybe you can clap with your little signal. And thanks everyone for attending today.
Thank you.
Thank you, John. Thank you, Mbak Rini.
Thank you, everyone.
Thank you, Bu
John.
Rini. Sukses selalu.
Thank you. I'm going to close the webinar now.
All right. Thanks, Nuka.
See you on the other side.
Nuka.
Yeah, catch up on campus.
Yes.
Sure.
Okay.
All right, well done, Rini.
Okay, thanks, John.
Bye, everyone.